Asante sir.
Senior Counsel, I'm Olive Mugenda, Commissioner representing the public and chairing these interviews. We also have the Secretary to JSC and also the Chief Registrar of Judiciary, Honorable Anna Madi.
Good morning, Senior Counsel.
Good morning, CRJ.
And we also have Frida Mukaya, who is the Registrar of JSC, at the corner there. Thank you. So a few housekeeping issues, Senior Counsel. Please feel free to ask commissioners to repeat a question if you're not sure or to clarify. After 2 hours or so, we will have a short break. And Madam Anna Madi will escort you to where you're going to have your break. Otherwise, it's supposed to be a conversation, Senior Counsel, so you should all relax and have the conversation. So I'll kick off the interview by giving you 5 to 10 minutes, Senior Counsel, to tell us why you feel you are the best suited candidate to be CJ. And I will just 5 to 10 minutes because the other issues will come with the commissioners. Thank you.
Asante, Professor. Perhaps I should first and foremost say I started my legal career at Attorney General's Chambers in 1980. That was the first place I was employed. Within a relatively short period of time, I was allocated very many difficult briefs. I'll mention only 2. I was involved together with the head of station, or head of my section, Mr. Frank Shields, with the acquisition of the land where Kasarani Sports Complex is constructed. The owners of that parcel of land, a company called Salopia Limited, had objected to government acquiring that land because we were using the Land Acquisition Act. And it's a prerequisite in that act that when government is using that act, it's got to be for a public purpose. And because of what was then happening, the owners were saying, this is nothing more than government taking this land for its own purposes. We did overcome that formidable challenge, and after overcoming that challenge in the High Court, then we went on to the issue of compensation. It was handled by the chief valuer, and that is why this republic has a near Olympic stadium at Kasarani. Soon thereafter, Attorney General nominated me to look at a very difficult problem that has persisted in this country, or had persisted in this country from the time of independence. That is the difficulty of an international boundary between Kenya and Sudan. I was entrusted with that task. Ultimately, government, together with the British Council, sponsored me to undertake a Master's in Law program at London School of Economics, and as part of the LLM program, to undertake original research in Kenya-Sudan boundary. I was at LSC. I spent numerous hours at Public Records Office because commissioners, all the documents of this republic during the colony and protectorate status, all those documents are at Public Records Office. I'm sure commissioners, you know where Public Records Office is towards Heathrow Airport at Kew Gardens. So I had to commute from LSC, which is at the Strand, and go to this Public Records Office every other single day, and I acquired a wealth of material. In 1 minute, commissioners, at the turn of towards 1914, the boundary was defined by the British government as a straight line between 2 fixed points, or in the alternative, such a line that would give to us the customary grazing grounds of the Turkana. Those grazing grounds were never defined, but towards 1938, a survey party established that the boundary was slightly above the straight line. That was not to be. We went on, and Sudan demarcated what they call 1950 Sudanese patrol line. That Sudanese patrol line is what actually triggered my interest in this area. And by application of principles of international law, I actually established that when any government allows a competing government to administer an area, the doctrines of acquiescence, doctrines of renunciation of territory, they all kick in. I hope we'll have an opportunity to discuss this in greater detail, but in one sentence, we were able, or I was able in my research, to establish that the Sudanese patrol line, which is a considerable distance from the straight line, is now the international boundary. So, Commissioners, I'm sure you all remember, in 1980s, the Kenya-Sudan boundary was indicated as a straight line. Then in 1985-86, we had an extended boundary that went towards Sudan. The difference in graphic terms is that through this research and the validation that went on in government, we were able to change our international boundary from the straight line to the new boundary, and we acquired 9,680 square kilometers. To put it in context, the former Western Province was 7,400 square meters. So we acquired a territory larger than the former Western Province. This is one of my research papers. It went through government, it went through validation. I cannot say that it was singular effort. The Attorney General and other organs of state all participated, and ultimately we changed our boundary. I then went to private practice from 1987. I've conducted numerous cases. Of interest would be I acted for ECK in the Kriegler Commission and also in the Waki Commission, where it was demonstrated that weak laws, weak institutions, weak governance structures can actually collapse any republic. Kriegler Commission report demonstrated and illustrated the weaknesses which were within our legal system and the lack of capacity in the electoral process and the lack of independence in the judiciary. I was part of a team. My team leader was John Musyoka Annan. I was his able assistant, and we also had Nyamodi. Paul Nyamodi is one of my colleagues. A team of 3, we represented ECK. It was a gigantic effort. We learned so much about the need to have proper laws and proper capacities in key institutions that deal with elections and the need to have an independent judiciary. Professor, thereafter, I've given my CV. I was instructed to work for National Assembly, and this is interesting, against the Senate in an advisory opinion at the Supreme Court. You may remember that there were the tough wars at the beginning of the 2010 Constitution, which is the superior house. But like lawyers, we do what we know best. We posed what appeared to be a very innocuous question. Which house should originate a money bill? But behind that innocuous question was whose business is it to legislate division of revenue bill? Because if it came to be my client, National Assembly, to legislate division of revenue bill, it means then we're in total control over devolution. And Senate was saying, no, it can't be. it is a joint effort. We came to Supreme Court, we argued on this matter. I lost, but with one dissenting judge saying that the issue was not justiciable. With that loss, devolution became entrenched as a principle that must be followed. But that was not the end of it. Barely 2 years ago, I was again instructed by the Council of Governors also about division of revenue bill. This time because the opinion that had been given to both houses was being ignored. I did that matter, and the Council of Governors was quite happy with the outcome. In between, I have conducted many other cases, and in my view, if I could summarize in 1 minute, you've had a CJ from academia who did wonderful work. I've looked at his transformation agenda. Allow me to say this with tremendous respect to my former lecturer. It is as profound or second in as profound to the Constitution. I can't see any other agenda as profound as Chief Justice Mutunga's agenda. Then you had a judge of this court as a Chief Justice with his agenda, which took us to another level. We have more magistrates, more judges, courts all over the country, a wonderful experience. But what you now lack is somebody who has been a consumer of this service. I've been knocking at the doors of the High Court, Magistrates Court. I've been to all the courts in this republic. I have had that eye that no other would have. For 40 years, I've been in Magistrates Court everywhere. I've been as far as Lokitang. I've been in every part of this country. We had 14 High Court judges at 2011. I've been to each of those. I've been to every Court of Appeal station in this country. When Supreme Court started, I was one of the early practitioners in that court. I have practiced in that court. I have wonderful professional relationship with the judges of that court. And I do believe, Professor, that I have that eye, a practitioner's eye, that can be able to see the real weaknesses and the perceived weaknesses and come up with a transformation agenda slightly advanced from access to justice. From access to justice to another agenda that would be, which we will discuss as we get along. Thank you, Prof.
Thank you very much, Senior Counsel. Clearly, Senior Counsel, you are a successful lawyer, Senior Counsel by all standards, given what you have told us and also what you have read from your CV. What I haven't heard, Senior Counsel, that I want you to explain to us is I've not seen much evidence of Mr. Ngatia, the leader. So please demonstrate to the Commission and to the public that you are that transformative leader we are looking for. I'm interested in tangible achievements in leadership and also maybe institutional changes that you have done, and that can be attributed to your leadership excellence, Senior Counsel.
Thank you, Prof. Prof, of course, I must also acknowledge your transformation of an ordinary college to iconic status. So allow me to pick a college, a university college, as an example. I have so many examples, but allow me to take a university college. Commissioners, you may all recall, University of Nairobi, virtually every now and then students will go on strike. It became so perennial that we were wondering whether we should have a university next to the human population around the city of Nairobi because of the rampant wastage that used to happen. About 3 or 4 years ago, I was requested by the Senate to look for what are the EU's